Доброго дня.
Good afternoon, dear ladies and gentlemen. Greetings to those who joined us here today, who watch us online. The topic of the next press event presentation of the free mobile application basic standards of investigation. Our speakers are Jordash, Managing Director of Global Rights Compliance, Nadiya, Volkova, Director of NGO Ukrainian Legal Advisory Group, and Oleksandr Sedov, expert of the Crimean Human Rights Group. Welcome. You're given the floor. Good afternoon. The topic of my presentation, I would like to share it here and online. This is about documentation of war crimes, and we believe that this app is to help those who document war crimes, both for state bodies and for NGOs and for first responders, for those who witness these crimes, how they document these crimes, in order to provide this information to international courts. I remember when we first started to document and we prepared our first communication to International Criminal Court, I had a panic attack because I didn't know how to formulate it and what the standard is, how to provide information, and what types of evidence is needed in order that information that we send to the Office of Prosecutor of Criminal Court, in order that it is taken into account in a proper way. Then I remembered that I had some contacts. There were some people who could share experience, and I addressed Wayne, and he helped me with 2 examples of such communications, and we took this into account, and we really used this as our base. So this communication was not bad, but we watched other organizations and law enforcement bodies that faced the same problem, and they were trying to use their fantasy or their logic, their thinking, how to formulate all this. I understood that we are not alone in this, and we were in a vacuum, and the problem appeared how to do this, and we had to do it quickly, because once you get evidence, you should document them properly, and there is also always a risk that the evidence can be lost, or a person who provides evidence or provides some explanation about what they saw, what they hear, maybe they can forget all these circumstances or details in some time, and the base in this way is evidence base is weakened in this way or lost. And last night I didn't relax. I started to look through this application, and I was really excited, and I forgot that it was 2 a.m. and I have to speak here today, and this is a useful application. And I had a bright idea yesterday. I believe we should have it from the very start, but the situation didn't really change a lot. We have some experience, some cumulative experience. We send several communications to International Criminal Court, and the same, we send information, and we also follow cases in European Court on Human Rights, and some standards also are used when we are speaking about international humanitarian law in these cases. And now it is really important to understand that we are at this stage. 6 years of conflict we have now, and we understand what information is sent to some international bodies, And the main issue for us, this is the issue of standards, this is the issue of quality, because several times we met with the prosecutor of the criminal court, and we heard feedback from the prosecutors that the information that they get, sometimes it is not properly presented, and they cannot understand the idea about what they got and how they can analyze it. And all this is ongoing because a big volume of information is provided, but it is not standardized, and quality is not always correspond to what it should be in reality. That's why I hope that those who work on this topic and those who will use this application, and we will do it, and we thank GRC for making this step into the future, and we now may use this, and we hope that it will get proper support. Thank you. Good afternoon. And I represent the Crimean human rights group, and I would like to tell you about the problems we face when we record the violations of international humanitarian law. So humanitarian law and international humanitarian law, when we deal with these issues, we understand that human rights, independent on the context, they should remain, they should not be violated. And if we are speaking about international humanitarian law, we should understand what the circumstances are those that correspond to the requirements of international court. And first, Crimea is the occupied territory. The situation in Crimea is the international conflict between Russia and Ukraine that is ongoing, and all the actions of the occupant state should be seen through the prism of international humanitarian law. Only after this we may consider these violations. And not always these crimes coincide. If we are speaking about torture, this is the same, but if we take information that we provided last year about call up to the army, so this call to the army is not human rights violation in itself, but we should take into account that that Crimea is occupied territory, and this is ongoing international conflict. And in this case, this is a crime that should be recorded. Now, we decided that this is under this jurisdiction. This is a violation. Some issues appeared. And what is the evidence of this recruitment to the army, conscription to the army? So we had to gather information that would be relevant for the prosecutor's office of the International Court, and it was difficult to select this information and whether evidence is enough, and whether this evidence will be accepted. Sometimes the information is ideal, but it is difficult to prove that this really happened, and sometimes we had to reject some evidence. Also, there were issues concerning collection of information, because information from open sources, and whether these decisions are relevant, and we compare information from open sources and closed sources, and also how to store information, how to transfer this information, how to store it, not to lose relevance of this information, to prove that this information can be accepted by the court. After collection of evidence, new issue arises: who is responsible, and whether these are the members of the Commission or the commissariats or the administration of Crimea or the leadership of Russian Federation, who creates conditions for this conscription. And after this, we should prove that these people related to this case. So a lot of information should be collected about one fact of this violation of international law. So, and in each aspect, we had a lot of discussions concerning each issue because there was no proper strategy how to store information, how to transfer information, how to document it, how to systematize it. And at the end of last year, I found this information, and if we had this application before, we wouldn't have so many questions. So I looked at this application of global rights compliance, and it provides proper grounds how to collect information, how to start collection of information, and there are also information. There is also information how to provide this information to ICC in order that ICC accepts this information. And I believe the more people collect this information about violations of international humanitarian law in the occupied territories of Ukraine, the more people have it, the less they have questions, and they will provide quality information. They will provide more bigger volume of information, and there will be bigger chances that the people who commit crimes in the occupied territories will be brought to responsibility. Thank you.
To my two colleagues. My name is Wayne Jordash, and I am the managing partner of Global Rights Compliance, which is a foundation in The Hague that specializes in bringing accountability for violations of international law, looking at the full spectrum from building the capacity of state authorities to implement international humanitarian law standards, and expertise in evidence gathering in relation to conflict-affected settings, and assisting communities to seek remedies for violations and providing access to meaningful redress for failures of states to enact reform or to address resulting IHL and international criminal law violations. Today, I am delighted to present the launch of the Russian version of the mobile app that GRC has been working on since 2016, and which was initially launched in May of 2019 in English only. Why do we say the app is important and potentially a game changer? The Basic Investigation Standards app is a free mobile app that can be downloaded worldwide on Android and Apple and used in locations with no mobile connectivity. As you've heard, in digestible form, the BIS app provides a distillation of up-to-date international standards that enable the user to document IHL, international humanitarian law, and international criminal law compliance. And it also goes on then to enable the user to integrate those standards into a range of humanitarian activities, including documenting international crime violations. So the standards contained in the app range, and I'll come back to this, but they range from standards which enable the user to identify and apply international humanitarian law prohibitions and obligations, assess such things as when genocide, war crimes, or crimes against humanity may be occurring, collect and preserve relevant documentary, physical, and digital and testimonial evidence in respect of these violations, ensure the safety and security of witnesses and victims, and provide it provides a range of other relevant guidance in relation to prohibition, prevention, and punishment of IHL and ICL violations. Now, the app was created to meet specific challenges. As identified by ICRC, there is a global deficit of technical IHL knowledge, integration, and implementation in conflict-affected areas, and in the various responses to humanitarian crisis. And this deficit is a deficit which impacts upon protecting war-related victims, whether investigating past international criminal law violations for criminal trials, or negotiating access to ensure the passage of unimpeded humanitarian relief. The fundamental challenge, as recognized by the ICRC, is the dissemination and translation of relevant international humanitarian law standards into appropriate behavior. None of the existing IHL or ICL tools provide the type of ready access to the relevant standards as provided by the app. It is the only tool in the market that provides ready and comprehensive access to relevant international criminal law standards and accompanying advice that can provide the user with dynamic, ready-made access at the press of an icon on a mobile phone. Our ambition in global rights compliance is to ensure the widespread adoption and deployment of the app into the global community, into the community that works in conflict-affected regions. Already, the app is beginning to be deployed. It has been used by the Crown Prosecution Service in the UK. It has been disseminated to 2,500 members of the Coalition for the International Criminal Court, and it's been recommended by a number of CSOs to be used in relation to the new international mechanisms such as the IIIM for Syria and the IIM for Myanmar, and I'll come back to those in a moment. So who are its users? First of all, organizations or entities with a reporting or judicial mandate. During the late 20th century and early 21st centuries, UN-mandated international criminal tribunals were introduced. The ICTY, the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, and these mechanisms, and of course the International Criminal Court. And these mechanisms, to a larger extent, relied upon professional investigators. These new, however, the new forms of accountability, the IIIM, which I mentioned a moment ago for Syria, the IIM for Myanmar, but also the ICC, rely heavily upon the engagement of civil society organizations who are required to document and investigate international violations of international humanitarian law and violations of international criminal law. These organizations are now relied upon to gather and document international crimes to enable these mechanisms to do their work. In relation to the IIIM and the IIM, these are mechanisms which are collating information to be able to build international cases. And as you will appreciate with the International Criminal Court, the process begins with international organizations, with CSOs, that's civil society organizations, gathering information and sending it to the ICC. In other words, the importance of civil society organizations in this space has increased hugely over the last few years and will continue to increase. International accountability mechanisms now cannot operate without the work of these CSOs. But it doesn't just stop there. The users of the app will also and should include organizations with a humanitarian mandate which goes beyond the investigation of international criminal law violations. Most organizations with a humanitarian mandate will be called upon to apply international humanitarian law standards and called upon to understand when violations of international humanitarian law turn into war crimes and when violations also amount to international core international crimes. These assessments are important for organizations with a humanitarian mandate who are not looking to prosecute crimes, but nonetheless require these standards to be able to operate in the field, to be able to craft effective responses to protect war-related victims. And I'm including in this these organizations, such organizations as MSF, the World Food Programme, the International Rescue Committee, Save the Children, and the Islamic Relief Society. These organizations, as you will appreciate, essentially offer services pursuant to a humanitarian mandate to assist victims of war. However, their mandates require them to understand international humanitarian law standards, international criminal law standards. Only through understanding these standards can these organizations really leverage the type of access, leverage the type of relief that they need to deliver to be able to protect war-related victims. This is what the app purports or hopes to be able to achieve. Turning to Ukraine specifically, and my two colleagues have addressed these issues, but in 2014, Ukrainian investigators, Ukrainian prosecutors, Ukrainian CSOs, civil society organizations had to face the challenge of dealing with justice in relation to armed conflict. As over 2 decades of experience at the international tribunals have shown, these issues are complex. The issues that arise in relation to international criminal law and international humanitarian law are complex. The investigation and prosecution of these violations are complex. The app attempts to synthesize and crystallize this expertise and experience so that it is readily accessible to those who have had little or no experience or those whose experience is really developing. As we know, 6 years into the conflict in Ukraine, there's been very few criminal cases against perpetrators of war crimes arising from Donbass, arising from Crimea. There are many good reasons for that, including the difficulty of obtaining suspects, but also the difficulty of obtaining evidence. But there is a further difficulty, and which is what the app attempts to address, and that's the difficulty, the deficit of a lack of knowledge of the applicable law. The mobile app is now in Russian, is designed to remedy these deficits. Having a source of international humanitarian law expertise and international criminal law standards in your pocket will enable investigators and prosecutors and civil society organizations to be able to access the necessary expertise. And so moving just finally to what the app actually contains. Prior to drafting the contents of the app, we went through all the available existing international humanitarian law and international criminal law guides and manuals. There are many of them, but despite their high standard and despite the fact that they're comprehensive, they are essentially very dense and essentially very complicated. Not, in our view, the best way to crystallize the expertise. And so what we did was we crystallized that expertise, we created a paper manual in the first instance, and then we developed the Basic Investigations app. And it's the first tool, as I've said, to comprehensively address the challenges of documenting IHL violations and international criminal law violations and crystallizing it in a way which is user-friendly. And so the app contains a range of chapters. It has 6 chapters. First of all, an introduction, which introduces the user and the practitioners to a range of useful definitions about evidentiary standards and investigation and prosecutorial standards. Chapter 2 details 10 essential investigative rules, comprised of essential investigative and ethical principles which are absolutely vital for all practitioners to institute into their investigative and documenting activities. Chapter 3 deals with preparing for an investigation. And as I said, this is not just for those investigating for criminal trial purposes, but for anyone who is interested in documenting how IHL is being complied with or not complied with, and how international criminal law is being complied with or not complied with. Chapter 4 is a specific chapter on collecting and preserving information and evidence. Once a practitioner is ready to investigate, they should read the standards in this section, in this chapter, which include standards and procedures to be followed when collecting physical, documentary, digital, and testimonial information. It is essential that the practitioner follows the guidance on how to interact with witnesses and victims in order to protect them from further harm. Chapter 5 are the critical elements of international crimes. This section discusses the elements of international crimes and how the practitioner should approach their investigation in a structured manner, including guidance on how to develop a case theory and how to build an effective criminal case or complaint. Chapter 6 deals specifically with the ICC and Article 15 communications. The guide includes a brief introduction to Article 15 communications and a detailed template for the preparation and delivery of Article 15 communications to the ICC. It includes responses to frequently asked questions encountered by our lawyers in GRC in the course of our work over the last few years. These frequently asked questions relate to general Article 15 communications, what format they should take to be most useful, what structure they should take to be most useful, and what the content of them should be to be most useful for the ICC. In summary, if you want a quick, easy-to-follow guide on how to investigate international humanitarian law violations, the ingredients of an international crime, tips on how to investigate specific crimes, and examples of useful evidence, then the app will help you. These are all essential issues for how to build an international criminal law case, from the bottom, from the ground, upwards, towards those who, in the highest political and military circles, who hold or may hold the most responsibility for the violations at the ground level. Finally, Chapter 6 of the app provides a template for the submission of Article 15 communications to the ICC. Whilst the topic of the app does not overall just include communications to the ICC, it is important to note the ICC's important position in relation to international criminal law violations for Ukraine and beyond. And so we have included in the app a clear methodology for submitting information to the ICC. But conversely, if you are not interested in the ICC, but you are, for example, the OSCE or OHCHR in Ukraine, and you're interested in understanding when conduct by a warring party crosses the line from lawful conduct to violations of international humanitarian law, and when those violations of international humanitarian law then move into the war crime territory, i.e. when do they amount to a war crime, then again, the app will help you. And finally, if you're an international humanitarian organization interested in consolidating and fortifying your own mandate to protect war victims through understanding where lawful conduct again moves into unlawful conduct and where unlawful conduct moves into war crimes, again, the app will help you. Finally, what the app also does is it has a section which enables you to contact global rights compliance lawyers. global rights compliance team of legal experts who have years of experience in this field will be able to answer any questions which are posed through the Contact Us section of the app. We are more than willing and able to answer those questions when and if they arise in the field, as inevitably they will. So finally, download the app on Android and Apple, search for GRC's Basic Investigation Standards app. And the best thing about the app, besides its content, which I've described, is the fact that it's completely free. Download the app and it will enhance your work. Thank you very much.
Шановні гості, якщо маєте запитання до спікерів, прохання піднімати руки, представлятися.
If you have questions to speakers, please, no questions and comments. Thank you very much. So this is end of press briefing.